This is Mac William Bishop for DealBook at the New York Times. It has been called the biggest insider trading trial in a generation. One of Wall Street's most successful investors will appear in federal court beginning March 8th to face charges that he made more than $45 million trading on illegal stock tips.
Well, it's going to be a landmark case as far as the Justice Department is concerned. Right now, there's a big perception on Main Street that Wall Street is in fact rigged and that the privileged have advantages over those who do not have the wealth and power as Mr. Rajaratnam has. So it is of great significance to the Justice Department to send a message that those folks are not above the law.
Rajaratnam co-founded the hedge fund Galleon Group. In the insider trading case against him, prosecutors have used investigative tactics once reserved for organized crime and narcotics trafficking.
The use of wiretaps has traditionally been within the realm of drug enforcement actions. To use it in the white-collar context is indeed unusual and novel, and I think it sets the tone for white-collar investigations going forward.
The government's case against Mr. Rajaratnam has cast a spotlight on the hedge fund industry, which has become one of the most powerful forces on Wall Street. It will also bring a number of high-profile finance executives to the stand. This could potentially include even Lloyd Blankfein, the chief executive of Goldman Sachs. In addition to a wealth of recorded conversations obtained through wiretaps, the case will also hinge on testimony from Mr. Rajaratnam's erstwhile co-conspirators. Many of them have already pleaded guilty and are cooperating with prosecutors.
In a case like this, if a person was to fight the charges and be found guilty, in many cases they would easily be facing between 10 and 20 years in prison. If they plead guilty and if they cooperate, they can often get that sentence down to somewhere between 2 years, 3 years, 4 years, something like that, depending on the involvement that they had and depending on how much they cooperate with the government.
Mr. Rajaratnam's defense team is expected to focus on the mosaic theory of investing, but former prosecutors think that Mr. Rajaratnam will have a hard time convincing a jury that he was just a very savvy investor.
Under the mosaic theory, what hedge funds do is they collect as much information as possible, and that includes private or non-public information. But that private non-public information can't be material. That is, it can't be really important, essentially. And so what the government's going to say is this private non-public information that Galleon was trading on was material. That is, it would have been important to a reasonable investor. And what Rajaratnam is going to say is that it was not material, but that to him, because he knew so much and had so much other information, he was able to divine its importance. But the reasonable investor in his situation wouldn't have been, and therefore he's going to seek an acquittal.
The case is also a test for the U.S. government's ability to bring white-collar criminals to justice. The U.S. attorney leading the case, Preet Bharara, has said that insider trading is rampant on Wall Street. The Rajaratnam trial is an important part of the government's efforts to deter financial crime.
Now, the reality of the situation is that insider trading is never going to go away. However, it's important that the government do cases like this from time to time to let people on Wall Street know that they're out there, and if they catch you, you're going to be severely punished. So I think that's really the lesson in this case.
But for Mr. Rajaratnam and the host of lawyers on the prosecution and defense, the only issue that will matter is that of guilt versus innocence. This is Mac William Bishop for DealBook at the New York Times.